Chapter 6. Compulsory Motor Vehicle Liability Insurance. SEC 386. For purposes of this chapter. A. Motor vehicle is any vehicle as defined in Section 3, Paragraph A, of Republic Act No. 4136, otherwise known as the Land Transportation and Traffic Code. B. Passenger is any fare-paying person being transported and conveyed in and by a motor vehicle for transportation of passengers for compensation, including persons expressly authorized by law or by the vehicle's operator or his agents to ride without fare. C. Third party is any person other than a passenger as defined in this section and shall also exclude a member of the household, or a member of the family within the second degree of consanguinity or affinity, of a motor vehicle owner or land transportation operator, as likewise defined herein, or his employee in respect of death, bodily injury, or damage to property arising out of and in the course of employment. D. Owner or motor vehicle owner means the actual legal owner of a motor vehicle, in whose name such vehicle is duly registered with the Land Transportation Office. E. Land transportation operator means the owner or owners of motor vehicles for transportation of passengers for compensation, including school buses. F. Insurance policy or policy refers to a contract of insurance against passenger and third-party liability for death or bodily injuries and damage to property arising from motor vehicle accidents. SEC 387. It shall be unlawful for any land transportation operator or owner of a motor vehicle to operate the same in the public highways unless there is in force in relation thereto a policy of insurance or guarantee in cash or surety bond issued in accordance with the provisions of this chapter to indemnify the death, bodily injury, and/or damage to property of a third party or passenger, as the case may be, arising from the use thereof. SEC 388. The Commissioner shall furnish the Land Transportation Office with a list of insurance companies authorized to issue the policy of insurance or surety bond required by this chapter. SEC 389. The Land Transportation Office shall not allow the registration or renewal of registration of any motor vehicle without first requiring from the land transportation operator or motor vehicle owner concerned the presentation and filing of a substantiating documentation in a form approved by the Commissioner evidencing that the policy of insurance or guarantee in cash or surety bond required by this chapter is in effect. SEC 390. Every land transportation operator and every owner of a motor vehicle shall, before applying for the registration or renewal of registration of any motor vehicle, at his option, either secure an insurance policy or surety bond issued by any insurance company authorized by the Commissioner or make a cash deposit in such amount as herein required as limit of liability for purposes specified in Section 387. A. In the case of a land transportation operator, the insurance guarantee in cash or surety bond shall cover liability for death or bodily injuries of third parties and/or passengers arising out of the use of such vehicle in the amount not less than 12,000 pesos, P12,000.00, per passenger or third party and an amount, for each of such categories, in any one accident of not less than that set forth in the following scale. 1. Motor vehicles with an authorized capacity of 26 or more passengers, 50,000 pesos, P50,000.00. 2. Motor vehicles with an authorized capacity of from 12 to 25 passengers, 40,000 pesos, P40,000.00. 3. Motor vehicles with an authorized capacity of from 6 to 11 passengers, 30,000 pesos, P30,000.00. 4. Motor vehicles with an authorized capacity of 5 or less passengers, 5,000 pesos, P5,000.00, multiplied by the authorized capacity. Provided, however, that such cash deposit made to, or surety bond posted with, the Commissioner shall be resorted to by him in cases of accidents the indemnities for which to third parties and/or passengers are not settled accordingly by the land transportation operator, and, in that event, the said cash deposit shall be replenished or such surety bond shall be restored within 60 days after impairment or expiry, as the case may be, by such land transportation operator. Otherwise, he shall secure the insurance policy required by this chapter. The aforesaid cash deposit may be invested by the Commissioner in readily marketable government bonds, and/or securities. b. In the case of an owner of a motor vehicle, the insurance, or guarantee in cash or surety bond shall cover liability for death or injury to third parties in an amount not less than that set forth in the following scale in any one accident. 1. Private cars. I. Bantam, 20,000 pesos, P 20,000.00. 2. Light, 20,000 pesos, P 20,000.00, and 3. Heavy, 30,000 pesos, P 30,000.00. 2. Other private vehicles. I. Tricycles, motorcycles and scooters, 12,000 pesos, P 12,000.00. 2. Vehicles with an unladen weight of 2,600 kilos or less, 20,000 pesos, P 20,000.00. 3. Vehicles with an unladen weight of between 2,601 kilos and 3,930 kilos, 30,000 pesos, P 30,000.00, and 4. Vehicles with an unladen weight over 3,930 kilos, 50,000 pesos, P 50,000.00. The Commissioner may, if warranted, set forth schedule of indemnities for the payment of claims for death or bodily injuries with the coverages set forth herein. SEC 391. Any claim for death or injury to any passenger or third party pursuant to the provisions of this chapter shall be paid without the necessity of proving fault or negligence of any kind, provided, that for purposes of this section, a. The total indemnity in respect of any person shall not be less than 15,000 pesos, P 15,000.00. b. The following proofs of loss, when submitted under oath, shall be sufficient evidence to substantiate the claim. 1. Police report of accident, and 2. Death certificate and evidence sufficient to establish the proper payee, or 3. Medical report and evidence of medical or hospital disbursement in respect of which refund is claimed. c. Claim may be made against one motor vehicle only. In the case of an occupant of a vehicle, claim shall lie against the insurer of the vehicle in which the occupant is riding, mounting or dismounting from. In any other case, claim shall lie against the insurer of the directly offending vehicle. In all cases, the right of the party paying the claim to recover against the owner of the vehicle responsible for the accident shall be maintained. SEC 392. No land transportation operator or owner of motor vehicle shall be unreasonably denied the policy of insurance or surety bond required by this chapter by the insurance companies authorized to issue the same. Otherwise, the Land Transportation Office shall require from said land transportation operator or owner of the vehicle, in lieu of a policy of insurance or surety bond, a certificate that a cash deposit has been made with the Commissioner in such amount required as limits of indemnity in Section 392. Answer for the passenger and/or third-party liability of such land transportation operator or owner of the vehicle. No insurance company may issue the policy of insurance or surety bond required under this chapter unless so authorized under existing laws. The authority to engage in the casualty and/or surety lines of business of an insurance company that refuses to issue or renew, without just cause, the insurance policy or surety bond therein required shall be withdrawn immediately. SEC 393. No cancellation of the policy shall be valid unless written notice thereof is given to the land transportation operator or owner of the vehicle and to the Land Transportation Office at least 15 days prior to the intended effective date thereof. Upon receipt of such notice, the Land Transportation Office, unless it receives evidence of a new valid insurance or guarantee in cash or surety bond as prescribed in this chapter, or an endorsement of revival of the cancelled one, shall order the immediate confiscation of the plates of the motor vehicle covered by such cancelled policy. The same may be reissued only upon presentation of a new insurance policy or that a guarantee in cash or surety bond has been made or posted with the Commissioner and which meets the requirements of this chapter, or an endorsement or revival of the cancelled one. SEC 394. If the cancellation of the policy or surety bond is contemplated by the land transportation operator or owner of the vehicle, he shall, before the policy or surety bond ceases to be effective, secure a similar policy of insurance or surety bond to replace the policy or surety bond to be cancelled, or make a cash deposit in sufficient amount with the Commissioner, and without any gap, file the required documentation with the Land Transportation Office, and notify the insurance company concerned of the cancellation of its policy or surety bond. SEC 395. In case of change of ownership of a motor vehicle, or change of the engine of an insured vehicle, there shall be no need of issuing a new policy until the next date of registration or renewal of registration of such vehicle, and, provided, that the insurance company shall agree to continue the policy, such change of ownership or such change of the engine shall be indicated in a corresponding endorsement by the insurance company concerned, and a signed duplicate of such endorsement shall, within a reasonable time, be filed with the Land Transportation Office. SEC 396. In the settlement and payment of claims, the indemnity shall not be availed of by any accident victim or claimant as an instrument of enrichment by reason of an accident, but as an assistance or restitution insofar as can fairly be ascertained. SEC 397. Any person having any claim upon the policy issued pursuant to this chapter shall, without any unnecessary delay, present to the insurance company concerned a written notice of claim setting forth the nature, extent, and duration of the injuries sustained as certified by a duly licensed physician. Notice of claim must be filed within 6 months from the date of accident, otherwise, the claim shall be deemed waived. Action or suit for recovery of damage due to loss or injury must be brought, in proper cases, with the Commissioner or the courts within 1 year from denial of the claim, otherwise, the claimant's right of action shall prescribe. SEC 398. The insurance company concerned shall forthwith ascertain the truth and extent of the claim and make payment within 5 working days after reaching an agreement. If no agreement is reached, the insurance company shall pay only the no-fault indemnity provided in Section 391 without prejudice to the claimant from pursuing his claim further, in which case, he shall not be required or compelled by the insurance company to execute any quitclaim or document releasing it from liability under the policy of insurance or surety bond issued. In case of any dispute in the enforcement of the provisions of any policy issued pursuant to this chapter, the adjudication of such dispute shall be within the original and exclusive jurisdiction of the Commissioner, subject to the limitations provided in Section 439. SEC 399. It shall be unlawful for a land transportation operator or owner of motor vehicle to require his or its drivers or other employees to contribute in the payment of premiums. SEC 400. No government office or agency having the duty of implementing the provisions of this chapter nor any official or employee thereof shall act as agent in procuring the insurance policy or surety bond provided for herein. The commission of an agent procuring the said policy or bond shall in no case exceed 10% of the amount of the premiums therefor. SEC 401. Any land transportation operator or owner of motor vehicle or any other person violating any of the provisions of the preceding sections shall be punished by a fine of not less than 500 pesos, p. 500.00, and / or imprisonment for not more than 6 months. The violation of Section 390 by a land transportation operator shall be a sufficient cause for the revocation of the Certificate of Public Convenience issued by the Land Transportation Franchising and Regulatory Board covering the vehicle concerned. SEC 402. Whenever any violation of the provisions of this chapter is committed by a corporation or association, or by a government office or entity, the executive officer or officers of said corporation, association, or government office or entity who shall have knowingly permitted, or failed to prevent, said violation shall be held liable as principals. Chapter 7. Mutual Benefit Associations and Trusts for Charitable Uses. Title L. Mutual Benefit Associations. SEC 403. Any society, association, or corporation, without capital stock, formed or organized not for profit but mainly for the purpose of paying sick benefits to members, or of furnishing financial support to members while out of employment, or of paying to relatives of deceased members a fixed or any sum of money, irrespective of whether such aim or purpose is carried out by means of fixed dues or assessments collected regularly from the members, or of providing, by the issuance of certificates of insurance, payment of its members of accident or life insurance benefits out of such fixed and regular dues or assessments, but in no case shall include any society, association, or corporation with such mutual benefit features and which shall be carried out purely from voluntary contributions collected not regularly and/or no fixed amount from whomsoever may contribute, shall be known as a mutual benefit association within the intent of this code. Any society, association, or corporation principally organized as a labor union shall be governed by the Labor Code notwithstanding any mutual benefit feature provisions in its charter as incident to its organization. In no case shall a mutual benefit association be organized and authorized to transact business as a charitable or benevolent organization, and whenever it has this feature as incident to its existence, the corresponding charter provision shall be revised to conform with the provision of this section. Mutual Benefit Association, already licensed to transact business as such on the date this code becomes effective, having charitable or benevolent feature shall abandon such incidental purpose upon effectivity of this code if they desire to continue operating as such mutual benefit associations. SEC 404. A mutual benefit association, before it may transact as such, must first secure a license from the Commissioner. The application for such license shall be filed with the Commissioner together with certified true copies of the Articles of Incorporation or the Constitution and bylaws of the Association, and all amendments thereto, and such other documents or testimonies as the Commissioner may require. No license shall be granted to a mutual benefit association until the Commissioner shall have been satisfied by such examination as he may make and such evidence as he may require that the association is qualified under existing laws to operate and transact business as such. The Commissioner may refuse to issue a license to any mutual benefit association if, in his judgment, such refusal will best promote the interest of the members of such association and of the people of this country. Any license issued shall expire on the last day of December of the third year following its issuance and, upon proper application, may be renewed if the association is continuing to comply with existing laws, rules, and regulations, orders, instructions, rulings and decisions of the Commissioner. Every association receiving any such license shall be subject to the supervision of the Commissioner, provided that no such license shall be granted to any such association if such association has no actuary. SEC 405. No mutual benefit association shall be issued a license to operate as such unless it has constituted and established a guarantee fund by depositing with the Commissioner an initial minimum amount of 5 million pesos, P5,000,000.00, in cash, or in government securities with a total value equal to such amount, to answer for any valid benefit claim of any of its members. All monies received by the Commissioner for this purpose must be deposited by him in interest-bearing deposits with any bank or banks authorized to transact business in the Philippines for the account of the particular association constituting the guarantee fund. Any accrual to such fund, be it interest earned or dividend additions on monies or securities so deposited, may, with the prior approval of the Commissioner, be withdrawn by the association if there is no pending benefit claim against it, including interest thereon or dividend additions thereto. The Commissioner, prior to or after licensing a mutual benefit association, may require such association to increase its guarantee fund from the initial minimum amount required to an amount equal to the capital investment required of an existing domestic insurance company under Section 209 of this Code. SEC 406. Every mutual benefit association licensed to do business as such shall issue membership certificates to its members specifying the benefits to which such members are entitled. Such certificates, together with the articles of incorporation of the association or its constitution and bylaws, and all existing laws as may be pertinent, shall constitute the agreement, as of the date of its issuance, between the association and the member. The membership certificate shall be in a form previously approved by the Commissioner. SEC 407. A mutual benefit association may, by reinsurance agreement, cede in whole or in part any individual risk or risks under certificates of insurance issued by it, only to a life insurance company authorized to transact business or to a professional reinsurer authorized to accept life risks in the Philippines, provided that a copy of the draft of such reinsurance agreement shall be submitted to the Commissioner for his approval. The association may take credit for the reserves on such ceded risks to the extent reinsured. SEC 408. The constitution or bylaws of a mutual benefit association must distinctly state the purpose for which dues and/or assessments are made and collected and the portion thereof which may be used for expenses. Death benefit and other relief funds shall be created and used exclusively for paying benefits due the members under their respective membership certificates. A general fund shall likewise be created and used for expenses of administration of the association. A mutual benefit association shall only maintain free and unassigned surplus of not more than 20% of its total liabilities as verified by the Commissioner. Any amount in excess shall be returned to the members by way of dividends, enhancing the equity value or providing benefits in kind and other relevant services. In addition, subject to the approval of the Commissioner, a mutual benefit association may allocate a portion for capacity building and research and development, such as developing new products and services, upgrading and improving operating systems and equipment, and continuing member education. SEC 409. Every outstanding membership certificate must have an equity value equivalent to at least 50% of the total contributions collected thereon. The equity value only applies to basic life insurance product and excludes optional products. SEC 410. Every mutual benefit association must accumulate and maintain, out of the periodic dues collected from its members, sufficient reserves for the payment of claims or obligations for which it shall hold funds in securities satisfactory to the Commissioner, consisting of bonds of the Government of the Philippines, or any of its political subdivisions and instrumentalities, or in such other good securities as may be approved by the Commissioner. The reserve liability shall be established in accordance with actuarial procedures and shall be approved by the Commissioner. The Articles of Incorporation or the Constitution and bylaws of a mutual benefit association must provide that if its reserve as to all or any class of certificates becomes impaired, its board of directors or trustees may require that there shall be paid by the members to the association the amount of the members' equitable proportion of such deficiency as ascertained by said board, and that if the payment be not made it shall stand as an indebtedness against the membership certificates of the defaulting members and draw interest not to exceed 5% per annum compounded annually. SEC 411. A mutual benefit association may invest such portion of its funds as shall not be required to meet pending claims and other obligations in any of the classes of investments or types of securities in which life insurance companies doing business in the Philippines may invest. It may also grant loans to members on the security of a pledge or chattel mortgage of personal properties of the borrowers, or in the absence thereof, on the security of the membership certificate of the borrowing members, in which event such loan shall become a first lien on the proceeds thereof. SEC 412. the Commissioner or any of his duly designated representatives, shall have the power of visitation, audit, and examination into the affairs, financial condition, and methods of doing business of all mutual benefit associations, and he shall cause such examination to be made at least once every 2 years or whenever it may be deemed proper and necessary. Free access to the books, records, and documents of the association shall be accorded to the Commissioner, or to his representatives, in such manner that the Commissioner or his representatives may readily verify or determine the true affairs, financial condition, and method of doing business of such association. In the course of such examination, the Commissioner, or his duly designated representatives shall have authority to administer oaths and take testimony or other evidence on any matter relating to the affairs of the association. All minutes of the proceedings of the Board of Directors or Trustees of the association, and those of the regular or special meetings of the members, shall be taken, and a copy thereof, in English or in Filipino, shall be submitted to the Commissioner's representatives or examiners in the course of such examination. A copy of the findings of such examination, together with the recommendations of the Commissioner, shall be furnished the association for its information and compliance, and the same shall be taken up immediately in the meetings of the Board of Directors or Trustees and of the members of the association. SEC 413. Every mutual benefit association shall, annually on or before the 30th day of April of each year, render to the Commissioner an annual statement in such form and detail as may be prescribed by the Commissioner, signed and sworn to by the President, Secretary, Treasurer, and Actuary of the Association, showing the exact condition of its affairs on the preceding 31st day of December. SEC 414. No money, aid, or benefit to be paid, provided or tendered by any mutual benefit association, shall be liable to attachment, garnishment, or other process, or be seized, taken, appropriated, or applied by any legal or equitable process to pay any debt or liability of a member or beneficiary, or any other person who may have a right thereunder, either before or after payment. SEC 415. Any member of a mutual benefit association shall have the right at all times to change the beneficiary or beneficiaries or add another beneficiary or other beneficiaries in accordance with the rules and regulations of the association unless he has expressly waived this right in the membership certificate. Every association may, under such rules as it may adopt, limit the scope of beneficiaries and provide that no beneficiary shall have or obtain any vested interest in the proceeds of any certificate until the certificate has become due and payable under the terms of the membership certificate. SEC 416. Any chapter affiliate independently licensed as a mutual benefit association may consolidate or merge with any other similar chapter affiliate or with the mother association. SEC 417. Any mutual benefit association may be converted into and licensed as a mutual life insurance company by complying with the requirements of the pertinent provisions of this code and submitting the specific plan for such conversion to the Commissioner for his approval. Such plan, as approved, shall then be submitted to the members either in the regular meeting or in a special meeting called for the purpose for their adoption. The affirmative vote of at least two-thirds, of all the members shall be necessary in order to consider such plan as adopted. No such conversion shall take effect unless and until approved by the Commissioner. SEC 418. No mutual benefit association shall be dissolved without first notifying the Commissioner and furnishing him with a certified copy of the resolution authorizing the dissolution, duly adopted by the affirmative vote of two-thirds, of the members at a meeting called for that purpose, the financial statements as of the date of the resolution, and such other papers or documents as may be required by the Commissioner. No dissolution shall proceed until and unless approved by the Commissioner, and all proceedings in connection therewith shall be witnessed and attested by his duly designated representative. No mutual benefit association shall be officially declared as dissolved until after the Commissioner so certifies that all outstanding claims against the association have been duly settled and liquidated. SEC 419. The Commissioner shall, after notice and hearing, have the power either to suspend or revoke the license issued to a mutual benefit association if he finds that the association has a. failed to comply with any provision of this code, b. failed to comply with any other law or regulation obligatory upon it, c. failed to comply with any order, ruling, instruction, requirement, or recommendation of the Commissioner, d. exceeded its power to the prejudice of its members, e. conducted its business fraudulently or hazardously, f. rendered its affairs and condition to one of insolvency, or g. failed to carry out its aims and purposes for which it was organized due to any cause. After receipt of the order from the Commissioner suspending or revoking the license, the association must immediately exert efforts to remove such cause or causes which brought about the order and, upon proper showing, may apply with the Commissioner for the lifting of the order and restoration or revival of the license so revoked or suspended. SEC 420. For failure to remove such cause or causes which brought about the suspension or revocation of the license of a mutual benefit association, the Commissioner shall apply under this code for an order from the proper court to liquidate such association. The provisions of Titles 14 and 15, Chapter 3, pertaining to the appointment of a conservator and proceedings upon insolvency of an insurance company shall, insofar as practicable, apply to mutual benefit associations. SEC 421. To secure the enforcement of any provision under this title, the Commissioner may issue such rules, rulings, instructions, orders, and circulars. SEC 422. The violation of any provision of this title shall subject the person violating or the officer of the association responsible therefor to a fine of not less than 10,000 pesos, P10,000.00, or imprisonment of not exceeding 3 years, or both such fine and imprisonment, at the discretion of the court. SEC 423. All provisions of this code governing life insurance companies and such other provisions whenever practicable and necessary, shall be applicable to mutual benefit associations. Title II. Trusts for charitable uses. SEC 424. The term trust for charitable uses, within the intent of this code, shall include all the real or personal properties or funds, as well as those acquired with the fruits or income therefrom or in exchange or substitution thereof, given to or received by any person, corporation, association, foundation, or entity, except the national government, its instrumentalities, or political subdivisions, for charitable, benevolent, educational, pious, religious, or other uses for the benefit of the public at large or a particular portion thereof or for the benefit of an indefinite number of persons. SEC 425. The term trustee shall include any individual, corporation, association, foundation, or entity, except the national government, its instrumentalities, or political subdivisions, in charge of, or acting for, or concerned with the administration of, the trust referred to in the section immediately preceding and with the proper application of trust property. SEC 426. The term trust property shall include all real or personal properties or funds pertaining to the trust as well as those acquired with the fruits or income therefrom or in exchange or substitution thereof. SEC 427. All trustees shall, before entering in the performance of the duties of their trust, obtain a certificate of registration from the Commissioner. The registration shall expire on December 31st of the third year following its issuance unless it is renewed. All provisions of this code governing mutual benefit associations and such other provisions herein, whenever practicable and necessary, shall be applicable to trusts for charitable uses. SEC 428. The treasurer of a charitable trust shall file a fidelity bond in the amount commensurate with the value of the trust property in his custody, as may be determined by the Commissioner. Chapter 8. Trust business in general. SEC 429. An insurance company may engage in limited trust business, consisting of managing funds pertaining only to retirement and pre-need plans, provided it has secured a license to do so from the Bangko Sentral ng Pilipinas. This trust business shall be separate and distinct from the general business of the insurance company and shall be subject to rules and regulations as may be promulgated by the Bangko Sentral ng Pilipinas in consultation with the Commissioner.